Welcome back to the deep dive. Today we're walking down a pretty dark alleyway of the law.
We really are.
Yeah, it's a situation that feels ripped straight out of a noir film or, a gritty crime drama. We are talking about that exact moment right after the gun goes off, where the money goes missing, and suddenly a friend shows up at your door asking for help.
It's a classic narrative trope, but
Yeah.
legally speaking, it's also a fascinating minefield. We're looking at post-crime today, and it really forces us to ask a very uncomfortable question for you as the listener. At what point does loyalty to a friend or a family member cross the line into criminal liability?
Exactly. I mean, we've all seen the movie scene where the hero or the anti-hero drives the getaway car,
Yeah.
or they hide a fugitive in the basement. Or maybe they just, keep their mouths shut when the police come knocking. And as an audience, we usually cheer for them.
Right, we do.
But in the real world, legally, these are distinct actions. They have very different consequences. So we're examining 3 distinct offenses today: accessory after the fact, misprision of felony, and compounding crime. What's our analytical path here?
Well, we need to be very precise because the law is incredibly technical in this area. So first, we will dissect accessory after the fact. This is the big one. We'll focus on the critical timing of the completed felony and the specific intent required.
Okay.
Second, we'll briefly address misprision of felony to determine if mere silence is actually a crime. And third, we will analyze compounding crime, specifically the exchange of value for silence. The ultimate goal here is to help you distinguish between moral failings and criminal interference with the administration of justice.
Right. So distinguishing the bad citizen from the actual criminal. Let's open the inquiry into the most complex doctrine here, which is accessory after the fact. Before we get into the weeds, what is the definition?
Under common law and most modern statutes, the general rule for accessory after the fact requires 3 distinct elements.
Just 3.
Just 3. First, a completed felony must have been committed by another. Second, the accused must have knowledge of the commission of that felony. And third, the accused must give aid to the felon personally for the specific purpose of hindering apprehension, conviction, or punishment.
Okay, I want to challenge that first element regarding the completed felony. It feels like a massive technicality. To explore this, let's analyze Little v. United States. First, what are the legally dispositive facts?
The facts here are tragic. The defendant, Little, was driving a car. His passenger shot 2 people. Little immediately hit the gas and drove the shooter away from the scene to help him escape.
Okay.
Crucially, though, at the exact moment Little drove away, the victims were still alive, they were critically wounded, and they died later. But when he drove off, they were breathing.
And what was the core legal issue?
The issue was whether a defendant can be convicted as an accessory after the fact to murder if the aid was rendered after the fatal blow was struck, but before the victim actually died.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the common law rule regarding the timing of accessory after the fact liability. The elements are, first, the aid must be rendered after the felony is completed. And second, for homicide specifically, the felony is not complete until death occurs.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the completion of the felony?
The court analyzed the nature of murder. The sub-rule is that murder requires a death, so the court applied the facts. At the moment Little rendered aid by driving away, the victims were alive. Therefore, the specific felony of murder had not yet been committed or completed.
And after analyzing all the elements, what was the court's final conclusion?
The court held that Little could not be an accessory after the fact to murder. The conviction was completely reversed.
Wow.
Now, note that he might have been an accessory to assault, but the charge was murder?
I really want to lock in this completed felony rule with a visceral hypothetical.
Go for it.
Okay, say I poison a rival, and they're in the hospital agonizing for 3 days, and during those 3 days, you hide me in your basement knowing exactly what I did. Are you an accessory to murder?
We have to apply the rule rigor here? No.
Really?
The victim is not dead. The murder is not complete. You are an accessory to attempted murder or assault, sure. But until that heart stops, you cannot be an accessory after the fact to murder.
That is a razor-thin margin. Okay, shifting to the second and third elements, knowledge and aid. What actually constitutes aid?
Aid must be personal assistance to the felon. This includes harboring, concealing, destroying evidence, providing a getaway, or inducing witnesses to lie, like we saw in State v. Doty.
What does it exclude?
It excludes mere failure to report out of charity. It also excludes refusing to consent to a search, as established in United States v. Prescott. Standing on your constitutional rights is not aid. It also excludes receiving stolen goods, which makes you a receiver, not an accessory.
I see. And what about the specific intent? Let's analyze State v. Clifford. First, what are the legally dispositive facts?
Clifford saw a wanted felon. When police asked Clifford if he had seen the felon, Clifford lied and said no. Later, Clifford testified he lied because he didn't want to get involved or be hassled, not specifically to help the felon escape.
And what was the core legal issue?
The issue was whether a lie to the police satisfies the mens rea requirement for accessory after the fact if the motive was self-interest rather than aiding the felon.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule requires specific intent. The elements are, first, the defendant must perform an act of aid, in this case, the lie. And second, the defendant must possess the specific purpose of hindering the felon's apprehension, conviction, or punishment.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the second element, the specific purpose?
The court looked closely at the defendant's motive. The sub-rule is that if the intent is solely self-serving, like to save his own skin or avoid police contact, the specific intent to aid the felon is absent. The court found Clifford's primary motive was personal avoidance, not hindering the felon's capture.
And after analyzing all the elements, what was the court's final conclusion?
The court held the defendant was not guilty. The specific intent to aid the felon was not legally proven.
That distinction really protects someone who is just scared. Moving on to misprision of felony. If I simply see a felony and walk away saying absolutely nothing, am I a criminal?
The general rule at common law was that misprision was the failure to report a known felony. But its current status is virtually obsolete or unconstitutional in state courts due to self-incrimination concerns.
But there is a federal exception, right?
Yes. 18 U.S.C. Section 4 exists, but it requires active concealment in addition to failure to disclose.
So referencing United States v. Ciambrone, does partial disclosure count as misprision?
It can. In Ciambrone, the court held that even a truthful but partial disclosure could be misprision if it intentionally misled the government. But mere silence is generally insufficient under modern federal applications.
Silence is safe. Half-truths are a trap. Let's introduce the final offense, compounding crime. Can I accept money to agree not to call the cops?
The general rule for compounding consists of 3 elements. First, an agreement not to prosecute or inform. Second, knowledge of the actual commission of a crime. And third, receipt of consideration, meaning money or property.
Let's test that consideration element. Let's analyze Commonwealth v. Peace. First, what are the legally dispositive facts?
The defendant accepted a promissory note, which is consideration, from a thief in exchange for an agreement not to prosecute the theft.
And what was the core legal issue?
Whether the acceptance of the note in exchange for silence constituted the crime of compounding.
What rule of law did the court apply?
The rule is that compounding requires the receipt of any valuable consideration in return for an agreement not to prosecute.
Now for the court's elemental analysis. How did the court apply the element of consideration?
The court determined that the promissory note had value. The exchange of this value for the pledge of silence satisfied the element. It distinguishes mere mercy, which is dropping charges for free, from a commercial transaction, which is dropping charges for cash.
And the conclusion?
The defendant was guilty of compounding.
So if a thief steals my laptop and I say, give it back and I won't call the police, am I a criminal?
We have to analyze the restitution exception. Under the Model Penal Code and many modern statutes, there is an affirmative defense if the consideration is merely restitution or indemnification for the harm caused. Society does not want to punish a victim for simply getting their property back.
That makes perfect sense. As we wrap up this deep dive, we need a way for you, the listener, to organize all of this. Can you synthesize this into a diagnostic checklist?
Absolutely. This is the exam framework. Step 1, check the relationship. Are they a principal or accomplice? If they helped during the crime, stop. They are an accomplice. If help came after, proceed to Step 2. Step 2 is the timeline check, the little test. Was the felony fully complete? Remember, murder requires a dead body. If not complete, no accessory after the fact.
Got it. Step 3.
Step 3 is the act check. Did they provide personal aid, like hiding, lying, or driving? Or just passive silence? Passive silence is not accessory after the fact and likely not misprision.
And Step 4.
Step 4 is the intent check, the Clifford test. Was the purpose to hinder law enforcement? or was it self-preservation?
Finally, step 5.
Step 5 is the money check. Did money change hands to stop a prosecution? If yes, analyze compounding. And always check for the restitution defense.
That framework is incredibly sharp. This deep dive really shows that while loyalty is a virtue, the law draws a hard line at actively obstructing the path of justice. It makes you wonder how these ancient rules apply to our modern digital lives, like when deleting a text thread for a friend suddenly makes you a criminal. Something for you to mull over. We will see you in the next deep dive.